Michael talked about atheism in general, and I want to talk about, in particular, the education system. We have different campaigns going for oaths and the healthcare system, particularly in relation to the National Maternity Hospital at the moment. So one of the areas where we're working on, and we have a campaign at the moment, is that we have made a formal complaint to the Controller and Auditor General, it's a constitutional position, over the misuse of public funds in the Irish education system. And we refer in particular in that complaint to two articles in the Constitution. And those articles are Article 42.4 and Article 44.2.4 in relation to the funding of schools. Those two articles are around the funding of schools. And a lot of people might be surprised to learn that there are actually conditions to the funding of schools. And under Article 42.4, one of the conditions is that the state has to have due regard for the rights of parents in relation to the religious and moral formation of their children. And before that, in the article, the state need only endeavour, and we looked up the Irish translation of that, and another translation, and it says the state need only try hard to fund religious schools or private schools. That's all it has to do, and that was upheld recently in the Burke case at the Supreme Court. The Supreme Court said the state need only endeavour, and only that, to fund private schools. So they need only fund private schools if those conditions are met. And one of the conditions is, under 42.4, is the state should have regard to the rights of parents in relation to the religious and moral formation of their children. Now, we got out our trusty Irish translation that the Constitutional Review Group used in 1995, and we discovered that it actually says the state should have due regard for the formation of the mind of children in relation to religious and moral affairs. Now, when you think about that, that's far more nuanced than faith formation. And we all talk about faith formation in schools. The word faith formation is not in the Constitution. So a condition of the funding of schools, before you fund schools, the state has to have due regard to the rights of parents in relation to the formation of their children's minds with regard to religious and moral formation. Now, moral formation would be a philosophical conviction such as atheism, because our morals would be based on our philosophical conviction, and we view the world through those eyes. We do not have the same view of the world as religious families would have. So families that have an atheist background have a philosophical conviction. So how does the state, when it's funding schools, or deciding, or endeavouring, or just trying hard to fund these schools, look at the rights of parents in relation to the moral formation of their children? It doesn't. It ignores us. It pretends we're not there. When we have this constitutional right, and that constitutional right is a condition of funding. Now, in the recent Supreme Court case, in the Burke case at the Supreme Court, and that was about the Leaving Cert during COVID and that, they looked at all this whole area of parental rights in the Constitution. And there is an area that is going to have a major change on the education system, we feel. It says, the Supreme Court says, Article 42.4, in requiring the state to provide for free primary education also places an endeavour, and only that, before the state to supplement and give reasonable aid to private and corporate education initiatives, and when the public good requires it towards other educational facilities or institution. An overall savour in the Constitution text, constitutional text, is that the state, in providing for free primary education and endeavouring to assist post-primary education in various forms, have due regard for the rights of parents, especially in the matter of religious and moral formation. This provision reflects a concern for upholding parental authority. The parental authority, a foundational pillar of the Constitution that accords with Article 41, recognising the family as the natural, primary and fundamental unit of our society. Hence, society is built around the family. So where are our rights in relation to the moral education of our children in schools, and in particular Catholic schools? We don't have them. We just don't have them. So I just parked that funding there, about our philosophical rights there on that, and we go to another area, which is Article 44.2.4. And it talks about legislation providing state aid for schools, and then goes on to say that students have a right to not attend religious instruction. Now, not attend, they put not attend in the Constitution. It's not a meaningless word. They could have left it out of that section of the Constitution. So, a condition of the state funding of schools, as children have a right to attend, say, denominational schools and not attend religious instruction. So what we're saying is that because our children are not supervised outside the religious instruction class, or another thing is get another subject, the Constitution condition for the funding of schools is not being recognised. And we've gone to the Controller and Auditor General about that. Now, just to build on this thing about the rights of parents that have philosophical convictions. Twice in Ireland, the courts have recognised that parents have philosophical convictions as opposed to religious convictions. Once in 1996, in the High Court in the campaign to separate church and state case, Justice Costello said that parents had rights in relation to the religious and their philosophical convictions, and he accorded that right, that it was a reflection of the right under the European Convention of Human Rights, and it is there under the Article 2 of Protocol 1 of the European Convention about the philosophical convictions. And another one is in a case in 2011 in the High Court. It was to do with blood transfusions and Jehovah's Witnesses, and Justice Hogan, and I think he's on the Supreme Court now, also spoke about the absolute right of parents in relation to their religious and philosophical convictions. So, we feel that a condition of the funding of all the schools in the state is that our rights in relation to the philosophical convictions, our philosophical convictions have to be respected. And it's the state's obligation to do that. At the moment, what the state does is that in relation to not attending religious instruction, it leaves it up to each individual school to how they do that. We say that that's unconstitutional, and because of, and particularly in relation to what the Supreme Court has said in the Burke case. Because the Supreme Court said that once there's a right in the Constitution, it's the obligation of the Department of Education to administer that right. They have to administer, so it's up to each the ministers over the years to administer the constitutional right to not attend. So the funding is given to the schools on the understanding that children not attend. Now, because that it says not attend is in an article on funding, it has to mean that the child is not left sitting in the back of the class. So the child needs to be supervised outside the class, and the funding given to the school has to cover that. And just because schools ignore that doesn't mean that the state is not obliged to ensure that they do that in practice And that's what we're after. That's why we're complaining about the misuse of public funds in that area. Another area, then we go back into Article 42.4 and the right to our philosophical convictions, which, when you look at the Constitution, we're there, we're in it. It protects us. But what has happened is, over the years, with the power and the privilege of the Catholic Church mainly, who has control of all the schools, our rights have taken second place to a mission to evangelise. And in relation to inclusion and diversity, we look at those words a lot of time and they sound very nice and they all sound wonderful and everybody is inclusive and everybody tries to be inclusive. But what we have found out on the ground and from many parents is that they mean different things to different patron bodies, to different schools and to different teachers. There's no uniformity there over what are our constitutional rights, what does respect mean on the ground, what is the practical application of that on the ground. So in a way, those words, they're like buzzwords to us. What we're looking for is our constitutional rights. We want state guidelines, we want statutory guidelines on what does respect mean on the ground in schools. Respect, for example, should mean that our children are supervised outside, the least that it should mean, outside the religious instruction class. And we would be arguing on the grounds of equality that our children have a right to another subject. In relation to respecting our philosophical convictions, in the general atmosphere of the school, if we just park the religious instruction things, well, what does that mean? How does schools respect the rights of minorities when they're integrating their ethos into subjects? And under what law, under what constitution, and what article in the Constitution? There doesn't seem, we've looked at all the cases in relation to the legislation and the Constitution, and we cannot find anything that supports the rights of schools to integrate religion into the Constitution. Granted, you can take that from the Education Act under Section 15, that they have a right to their own ethos and that. But if we look at the campaign case in 1998 in the Supreme Court did say that schools had a right to their own ethos, but they said in the general atmosphere of the school, and it could only influence a child to some degree. That's all they said. And they went on to say that it wasn't practical anymore for community schools to combine religion and academic education the way that those schools used to do in the past. And they did refer to community schools as denominational schools. So ethos is the general atmosphere of the school outside the religious instruction class that somebody can opt out. It can only influence children to some degree. There's no guidelines on what that degree is. Every patron body decides for themselves what that degree. So is what is written down in the Supreme Court case. So where is it? Where are our rights? They are not available to us, and they are not available to us because of prejudice and discrimination against minorities, and in particular against non-religious minorities in the education system. So when we are campaigning for our rights, we are campaigning for our constitutional rights, we are campaigning for our philosophical convictions which are in the Constitution, and we are looking for a practical application through guidelines, statutory, law and practice on the ground in all Irish schools. Thank you.